Atiku Abubakar of the People's Democratic Party and Peter Obi of the Labour Party had earlier this month filed an application for the Presidential Tribunal to allow live coverage of the daily court proceedings so as to enhance transparency and boost citizens' confidence in the judicial process. Now, after various meetings, the five-member panel of the court, headed by Justice Haruna Tsammani, in response, rejected the application, said that there is no regulatory framework or policy to grant that application. Now, in a unanimous ruling, the court held that not televising the proceedings does not amount to a lack of fair hearing on the part of the petitioners. That's the focus of our discussion. Joining us in the studio to discuss more on this is a lawyer and public affairs analyst, Jide Ologun. Jide, good morning. Good to see you. Good morning.
Thank you.
Welcome.
It's my pleasure to be here.
All right. Now, a lot of people would say that it's good to test anything through the courts so that when the courts makes a pronouncement, then you know where you stand. And especially when the process is ongoing, the arguments about that whole thing will be made known so that people become more enlightened. But some people have not taken this lightly, that the live transmission of the Presidential Election Petition Tribunal or the proceedings there will be is being rejected. The application to transmit live has been rejected. This is not going down well with a lot of people.
Yes, but the application was made subject to the discretion of the court, and the 5 justices looked at it and took a decision. And it's quite interesting that we need to focus on the reasons given. And one of the reasons is that the court is not a stadium, neither is it a circus. And the court is known for the hallowed atmosphere, all right? It's a solemn environment. And that televising it does not touch on justice. And in particular, some of the cases cited in support of that application was the case of O.J. Simpson in the U.S., the case of 1994 to 1995, the case of murder, which was televised last, and at the end of the day, he was set free, and the case of Oscar Pistorius in South Africa. And the justice said that South Africa and America is not Nigeria. We don't even have it within our framework of rules and regulations of the court. And if we are so interested, I may suggest that we look at our laws and bring it in. And of course, for the school of thought, associating it with transparency. The court is a public space. All the parties are well represented. We even saw the drama between Abure and Apapa faction and things like that. So their lawyers are there. Some media organizations are allowed to come in. Whatever is important will be released. And there's this concept of witness protection. So you know how sentimental we are in Nigeria. So you go in there as a witness against a party and you are shown on camera. And you come out and people say, now this man, no. So these are all the issues. And I have advised, going to the tribunal in the first instance was a step of faith. If you didn't have trust in the tribunal, you were not compelled to come. So allow the tribunal to listen and to attend to the issues before them. And if you look at Section 131 of the Evidence Act, the one who comes to seek judgment in respect of a liability or a right is the one to prove the case. And the instructive case of Adeleke in Osun State is there. The court came to a conclusion that the former governor could not establish his case against Adeleke. So it's not about sensationalism. And one of the issues that the tribunal is trying to guard against is sensationalism, because during live broadcast, you may hear the comments of Mike and not wait to hear the comments of Jide, and you start posting your online judgments.
Exactly.
Like some of the experiences we had during the general elections where different posts were conferred. Some people compiled their own results and things like that. So we have these institutions. Let's allow them to do their work. And interestingly also, the consolidation was also approved, even though one party said no to it. So you find the justices moving on the path of justice, really. And again, one remarkable thing is that even when Labour Party is asking for 7 weeks to pull their arsenals together, the court is saying no, 3 weeks. We are time conscious. So the consolidation and the 3 weeks will give the tribunal speed in attending to these matters. All the pretrial applications and motions have also eaten into time. And APC will have 5 days and INEC to respond. So I think we should just give the benefit of trust. I don't want to say the benefit of doubt. Like I said, if you look at Section 65 of the Electoral Act 2022 as amended, it attaches the window of the tribunal intervening a court of competent jurisdiction. So if that has been part of our legal framework, let's allow it.
Especially since, or should I just say that another dimension to the tribunal's ruling on the issue of televised broadcasts of the proceedings, there was that the application for the live broadcast by the Labour and the PDP, the Labour Party and PDP didn't form part of their primary petitions
before the court.
Before the court, and I think that also needs to be broken down for people out there to also better understand that in law there is a process, and the jurists, the justices are bound to follow this process and not be distracted by this and that.
Definitely, particularly when you are trying to save time, and that is why, to start with, the life cycle of Elections Tribunal were fixed into the 180-day cycle, then the 60 days for if you want to go to the Supreme Court to appeal against it. So, and we are expected to be proactive. And sometimes, you find the bar and the bench playing these let's buy time tactics, but the court is saying no. We are not going to allow that, because if you have been monitoring critically, you will realize that sometimes the litigants may even be the one trying to slow the process down. So why don't you pull yourself together, present all you need to present before the court? And it's also good to build our jurisprudence. Now, if we are so interested in live broadcast of Elections Tribunal, push it to the National Assembly to amend the electoral laws to say that subsequently in Nigeria, if there's going to be any petition before the tribunal, it must be televised live. And that is good business for because the justices also made reference to the budgetary allocations. So, the application, but in court you can bring your applications. It's for the justices to attend to it. And like we say, as your lordship pleases.
And you also made an interesting point as a follow-up, to the previous question, how that if indeed we get to the point where the law does provide for it, it's also not immediate. There is a process that needs to be followed to ensure that the courts have these gadgets. So for a court now to be faced with an application of this nature, at this time that its mandate is even time-bound, how could that have even flown, on the face of it?
Yeah, if the justices decided that, okay, let's have live transmission, arrangements would have been made for it. But in the wisdom of the justices, and I understand, it may amaze you also that professionally speaking, even when you depose on oath in matters like this, you can use alphabets. There is what we call the witness protection. This is Nigeria. If somebody goes in there, for instance, to say, I'm a witness to Labour Party or PDP, and you come out, they see you in the marketplace. They say that demand be this. So you need to look at all these issues. And when you talk about sensationalism, sensationalism is presenting the narrative in an exciting manner without paying attention to accuracy. So if a lawyer rises up, for instance, for APC and blows all the grammar, blah, 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 and this person watching did not wait to listen to the lawyer of Labour Party, of PDP, of APM. Hey, they will say, hey, now you win now. Hey, so if you have chosen not to trust the judiciary, little can be done about that. But within our legal framework, within the ecosystem of electoral justice management, the tribunal is there. This is not the first time. Right from the Second Republic, you find this operating. And I have said it, if parties did not come to the tribunal, after all, AA and one other party decided to pull out. They were five. You know, so if you have not come to the tribunal will be busy attending to other issues. About 277 justices have been pulled for the sake of elections. And it is my desire that someday in this country, we get to the point where after our elections, we won't have to go to the judiciary, you know, but it's part of the value chain.
All right. Now, the tribunal has said no cameras as it is. However, does that also cover individuals who will come to the court with their phones? Because as much as you don't have the official big cameras from of real transmission, if you transmit using phones or you record and you send, as the case may be, it also amounts to transmission.
You know, I will advise against that. I said earlier, and that is very important, the court environment, it's a solemn environment, and I won't want anybody to go and, you need to come to court and see how it is. Even lawyers need to tiptoe, and let's trust these justices. You know, in a contest, someone wins, someone does not win. And so, and I'm not sure that also will be allowed. Why? So that you don't disrupt the process. Let me ask this simple question. If we went by the different postings, and I want people against it, during the general elections, the nation will be on fire now. But having done all, at the tribunal level, you bring your materials. You bring the there were videos that some were not even accredited. People were holding their fingers to thumbprint. Bring all these facts before the court. You see, and the court will look at it. 5 justices, appellate of the appeal court level. It's not a joke. And if you're not satisfied with what happens at that level, you proceed to the Supreme Court. And from 1963, the Supreme Court remains the highest court in the land. Look at the case of Adeleke. At the tribunal level, his victory was overturned. They proceeded to the Court of Appeal. It was reversed and finally confirmed at the Supreme Court. So those are 3 levels for the governorship. We have 2 levels now for the presidential. So let's wait and see. And for those who desire that all these matters be resolved before the swearing in, it's part of what the tribunal is saying, that, okay, cut down on time. The tribunal cannot be pushed. Okay, if the tribunal is rushing so much, they don't want to give fair hearing. So when you subject the judicial processes to public management and sensationalism, it's not the best. Because at the end of the day, you have come to the tribunal because you want them to adjudicate and come to a conclusion. And may I repeat that you are the one to prove your case. In the case of Osun State, the former governor made an allegation that in about 774 polling units, they were overvoting. It's about 10 local government areas. And bring the beavers, bring everything. And when you talk about elections, right from the polling unit to the National Collation Center, where the returning officer will make the final declarations. There are open opportunities for your full participation as a party. Your agents are expected to be there. Beyond the Beavers accreditation, the results will be posted. You can take the photographs. And so these are processes. These are processes. And if it ends up in the tribunal, then leave the justices to do their work. And they are now trying to streamline. Look at how long it has taken even the pre-trial season. So it's either we extend May 29 elastically, by elasticity, or we go back to the laws, which is another possibility, push it to the National Assembly. Section 4 of the Nigerian Constitution 1919 as amended says that the National Assembly shall make laws for the peace, order, and good governance of Nigeria. That, okay, going forward, all matters arising from our elections must be resolved before the swearing in of the president-elect, of the governor-elect. But as we speak now, constitutionally, May 29 is the date. So what do we do? So laws are made for the people. And if we have these legal frameworks, please, let's calm down and fit into it and allow the process.
Right, but eventually, where do you see all this going? Talking about this clamor for more transparency, more understanding of the workings of the courts through this proposed televised, the need for televised proceedings. Where do you see this all going? Because in India now, that has taken effect was it last year? In the United Kingdom too, we understand that in 2019 too, but of course it's not across board, it's not for all cases and in all courts, and in this instance of election petitions. Where do you see it all going? Or looking at Nigeria as that's been called a conservative country. Do you see this coming up, being entrenched in our legal system eventually?
It's up to us. The world is moving on AI now. So if we so desire, we can invest in it. But don't forget also that recently we embarked on the Naira swap. And technologically, the management was so poor, even till now. So do we have the basic amenities? And I also mentioned the budget. Okay, if the court says, let's have live transmission now, who bears the cost? There was an argument that a certain amount was supposed to be paid to INEC to access some materials. That was not paid. You are talking of live transmission of how many days, Mr. Mike? How much do you charge here for 3 hours?
Well, of course, the media stations are going to make money. That's what the thing is.
So these are issues. Like I said, it was done in the case of Oscar Pistorius, the case of O.J. Simpson, and let's take the case of Ekweremadu in the UK. The final decision was open. So we can adopt anything we want to adopt, but we need to invest in it. But within this time frame, the justices, they have consulted, they've sat down, they look at the pros and cons like in a debate to say, this is our position. And I've tried to raise some of the points. One of the points is that, before coming to the conclusion that that application lacked merit, is the fact that the court is not a stadium, it's not a circus, it's not a crusade ground, and there is need for protection of witnesses. What about if the witnesses now decide that we are not coming? Who do you blame for that? I don't want my face on camera. It is a very sensational season in the country. So when you put all this together, you can prepare for it in the future. After all, Beavers wasn't part of our electoral
system
processes,
all the while.
but now it's there. And we are still fine-tuning it. And if, as a researcher, you sit down to look at the impact of Beavers on our elections, it's not even as enormous as some are assuming and talking about it. And I can refer us to the comments of our senior colleague, Agbakoba, on it. So we need to look at these things deeply. And that was my argument, that you still have the regulations of the INEC. There is still discretion at that point in time. But then, by virtue of the Constitution, INEC is the umpire. And when you talk about transparency or no transparency. Where your party wins is transparent. Where your party did not win is not transparent. The same thing can be transferred to the tribunal. So let these justices do their work.
Okay. As we wind down now, we also you mentioned earlier how the cases have been consolidated. Now, for those who are non-lawyers, who are non-learned, what does this consolidation of the cases, what does it mean, and how beneficial is it to the process?
It's time-saving. Where the issues before the court are similar. What are they asking for? Annul that election, issues of nomination, issues of qualification, and if these issues are similar, rather than embarking on proceedings, you can bring everything down in one proceeding and proceed to save the time of the courts, And may I also say this to all our wonderful watchers, that you see, lawyers don't lose, and that is in court. You see, whether you win your case in court or you lose your case in court, you pay your lawyers. And that is why, if you are interested in justice, let them marshal their points. The justices will not do their cases for them. And I'm asking, please, let's calm down. If you have been monitoring, because if we make it sensational, we may be misled on these matters, So at this point in time, I want to request again that we try and monitor. And I know that the salient points in this whole process will be transmitted to the public to see. But
when the time comes.
Exactly. How are people getting to know it's consolidated? Through the media. So, do you know one thing again? Even some who are shouting live transmission, they may not even have time to sit down.
To sit down and watch.
Let's even assume the tribunal says it's live transmission. They have to go and sell their goods, go and make money to feed their family. So when they come, they ask, what happened? So what happened today? But then, if it will enhance the trust capital for those who claim they don't trust the judiciary in the future, make provision for it. But as we stand now, in the regulations and rules framework of our judicial system, there's no provision for it. It's not mandatory. And the Justice Tsammani also said it's novel. It's a new idea. But it may be a welcome idea, but perhaps not for this season. Okay, and finally, I don't know how transmitting it live will touch on the sanctity of integrity that he expected to run through the system. It may even end up being distraction.
Okay.
On all sides.
Right. We have to leave it here now. Thank you so much, Jide Ologun, for your insight into these issues. Of course, we look forward to greater days ahead.
Thank you, and God bless Nigeria.
God bless Nigeria, as you always say. Thank you.